Hello, everyone, and welcome to Uncivil Law. I hope you are having the most fantastic of days as always. And we are here with another edition of Supreme Court React. So, first, I should give a public apology to my chat participant, Dogbert, who in a prior stream asked me why I wasn't covering a particular case, and I came down on him with undue harshness, and that is my fault, not his. I like to admit my own errors when I make them because I'm still learning, and I apologize for being unduly snip. It was my failure, and I apologize. So we will get into today's case. This is the Supreme Court case of Monasky versus Taglieri, and I will read from the Supreme Court, or apologize, read from oye.org the description of the case. Michelle Monasky, a United States citizen married to D'Amico Taglieri, is an Italian citizen, claimed that Taglieri had repeatedly assaulted her before and during her pregnancy. Monasky returned to the United States with her 2-month-old daughter, and Taglieri asked an Italian court to terminate Monasky's parental rights. So we've got an American mother, Italian father, and the American mother returns with child to the United States. Italian father is asking the Italian court to terminate parental rights for the mother. Okay? All right. The Italian court ruled in Taglieri's, the father's, favor ex parte, that is without an appearance by Monasky, which makes sense because she had returned to the United States. So the Italian court says, Father, you're right. We're going to terminate the parental rights of the mother. Taglieri then asked a federal court to require that Monasky return the baby to Italy. The baby isn't in Italy, right? It's in the United States. So he's taking his Italian court judgment to the United States saying, please enforce this order. The court granted Taglieri's petition, finding that Italy was the baby's habitual residence. This is a 2-month-old daughter, but nevertheless, this is where the baby has habitually lived. Fine. A panel of the Sixth Circuit affirmed the district court decision, and then the Sixth Circuit agreed to hear en banc. I'm breaking up? I'm still showing pretty good throughput on my end. Still showing good bandwidth on my end, so it may be your end, not mine. But I will keep a watch of the bandwidth issue. Let's see. The International Child Abductions Remedy Act implements the Hague Convention in the United States and the... Yeah, if you're uploading my video, Matthew, that might be the problem. You're using your bandwidth. Anyways, the International Child Abduction Remedies Act implements the Hague Convention in the United States, and the law defines wrongful removal as the taking of a child in violation of custodial rights under the law of the state, that would be nation, in which the child was habitually resident immediately before the removal. So the Hague Convention says you can't remove a child if it is in violation of the law of the nation in which the child was dominantly resident. Okay. To determine the child's habitual residence, a court must look to the place in which the child has become acclimated, or as a backup inquiry, shared parental intent. Because the child at 2 months of age was too young to have acclimated to a country, makes sense, the relevant inquiry is the parents' shared intent. Okay. So this is the Court of Appeals saying we first look to where they become acclimated, but that doesn't make sense. They're 2 months old. They have no acclimation. Makes sense. So as a backup, shared intent. That's going to be the standard we're going with. The district court is in the best position to make an inquiry. That makes sense because it's a factual question, right? It's a question of fact. What was their intent? And finding no clear in the district court's finding as to habitual residence, the Sixth Circuit en banc affirmed. Okay, So they're saying the relevant issue, the Sixth Circuit Court of Appeals is saying the relevant issue is shared intent. They're saying the district court did a factual finding, and we're not going to upset that verdict. Makes sense. All right. Let me get to your questions in a second. Let me finish this first. Question: what is the proper standard of review of a district court's determination of habitual residence under the Hague Convention? What's the proper standard of review for the district court? What is the Court of Appeals? How are they supposed to look at this question? De novo, deferential de novo, or for clear error? So they're basically asking, is this a legal question or a factual question? Because I said to you, it's a factual question, but they're actually asking, is that a factual question or a legal question? Okay, fair enough. When an infant is too young to acclimate to her surroundings, its subjective intent between the infant's parents is necessary to establish habitual residence. So, is that the relevant standard? Okay, fair enough. So we understand the issue, right? Italian father, American mother, they have a problem. American mother takes child to the United States. Italian father asks Italian court for custody. He gets custody. And the issue is, where is the child habitually resident? Because if habitually resident in Italy, then it should be returned to Italy because they're a competent state and we abide by this convention. And if not, then I don't know, some other result should emerge. But that's the relevant question. So let me take a question of some of the questions that have been asked. All right. Dogbert says, I've read the ABA doesn't accredit any remote learning law school. As far as I'm correct, not for total remote learning, although some sort of online classes may be permissible. But to the best of my knowledge, there's no purely online school. That's true. New York lets you apply. New York, however, it's not ABA. Okay, so now he's confused about how bar admission works. I totally understand. I'm going to try to help your confusion. So we have two sets of systems in the United States. We have state systems and we have federal systems. They're independent courts, right? So they're independent standards. So first, you have to be admitted to a state. Because to the best of my knowledge, there's no federal court that will let you get admitted to a federal court without some kind of state admission. So, although theoretically they could come up with their own rule, but they don't want to administer a bar exam. So they say first you have to get administered to some state, any state. So I, for example, was admitted to the state courts of Virginia. I was sworn in by the Virginia Supreme Court. That entitles me to practice before any Virginia state court. But the state courts are separate from the federal courts. And I personally am not admitted to practice before any Virginia federal court because I've never bothered asking them for admission because I don't work in that space. I am admitted to the Court of Appeals for the Federal Circuit because that's where patent appeals go. And I'm admitted to the U.S. Supreme Court. Not that it's ever come up, but, I'm admitted there. So what Leonard's case was dealing with and what my case was dealing with is this guy wanted to be admitted to, I think it was the Eastern District of New York. That's a federal court. So the Eastern District of New York says to be admitted to the Eastern District of New York, you have to be admitted to the New York State Bar. And that's an unusual requirement because most federal courts don't have that requirement. Like my license would allow me to ask for admission to pretty much any federal court. I don't have to live there. So it's an unusual requirement. But that's the difference. He was not a member, or maybe he was, I don't know. But it doesn't really matter. He either was or was not a member of the New York State Bar, and he was asking for admission to the federal bar. So that was what was happening, what was going on. And DC is not a state. That's true, but they are, they still have their own state bar exam, so what do you want? Yeah. So that was what was going on in that case. Yes, every state allows you to sit for the bar if you go to an ABA school. That's true. And most states do not allow you to apply out of state if you go to a non-ABA school or otherwise get admitted. So I went to an ABA school, which means I can apply to any state bar. And because I'm admitted to at least one state, I can apply to pretty much any federal bar, but I could not apply to the Eastern or Southern District of New York because I'm not a member of the New York Bar. Because that's a requirement for some reason that, as Leonard was pointing out, doesn't really make sense because federal law is separate from state law. So, yeah, those are what is going on there. Okay. And there's one state, I forget, is it Missouri, where by graduating law school in the state, you automatically admitted to the bar of that state. So that's kind of nice. So there's one state, I think it's Missouri, where if you graduate law school in that state, you are now a member of the bar of that state. No bar exam. Kind of nice, I guess. But yeah, anyways. That's incorrect. Most states let you in after so many years of practice, even with non-ABA. Are you sure, Matthew? I mean, I would think that's not correct. I would think that most states require ABA, regardless of how many years you've been practicing. But I could be wrong. But I would have sworn it was the other way. I mean, most states allow you to waive in after a certain number of years, but I still think you have to have an ABA law school in those places. So, but I could be wrong. I could absolutely be wrong, but I would have sworn it was the other way. Anyways, let's get to the issue at hand for today. What if you're a member of the UK bar? Well, what of it? The UK is a different country from the US. So, yeah. What do you want? Anyways, let us start the oral argument of this case and let us listen to it. Oh, the UK is also interesting because to be members of the bar, you have to be a member of an Inn of Court. So, like, you get admitted to an Inn of Court, and so they do it that way. I don't think they have a bar as such, but they have these Inns of Court, which I don't understand how they work either. They seem kind of like a fraternal society, like a frat. So you have to get admitted to the frat to practice before the UK court. I don't know that much about UK law, guys. So, good times. Let us listen to the oral argument of this case and determine what the law is as it relates to Italian father versus American mother and unknown child, I suppose. So let's get started with this.
We'll hear argument first this morning in case 18-935, Monasky versus Taglieri. Mr. Tehrani.
Mr. Chief Justice, and may it please the Court, the Hague Convention on the civil aspects of child abduction is designed to protect children who have a country of habitual residence from the harmful effects of wrongful removal from that country. In this case, however, the convention was applied to separate 2-year-old AMT from her mother, the only caregiver AMT had ever known, and to return the child to Italy, a country where AMT had spent only the first 8 weeks of her life. The Sixth Circuit's decision upholding AMT's return to Italy rests on an erroneous definition of habitual residence. The Sixth Circuit held that AMT's parents could share an intent to raise AMT in Italy, even if they had no meeting of the minds. The Court never explained how parents can share an intent about where a child will live if there is no actual agreement between them. Tellingly, neither Taglieri nor the United States defends the Sixth Circuit's habitual residence standard. They instead urge this Court to adopt an amorphous all relevant circumstances inquiry. But in cases involving infants, the foreign jurisdictions on which Taglieri and the United States rely actually apply a different habitual residence standard. That standard focuses on the primary caregiver's connections to the country of removal, a far more appropriate inquiry. Ultimately, however, under any of the competing definitions of habitual residence and standards of review, the outcome of this case is the same. 8-week-old AMT was not habitually resident in Italy. Indeed, the district court's unchallenged finding that Monasky intended to return to the United States with AMT as soon as possible is virtually dispositive. This Court should put an end to this already 4-year-old litigation by entering an order directing AMT's return to the United States. I'd like to turn first to the definition of habitual residence. The Sixth Circuit applied a shared parental intent standard in name only because it held that AMT's parents could share an intent for her to live in Italy, even if they had no meeting of the minds or actual agreement on that issue.
All right, so Couple things of note of the start here that's pretty interesting. So we got competing standards, competing ways to measure this. Someone's asking for an all circumstances test. Someone's asking for this habitual standard test. So there's a lot of different confusions about the standard to be applied. So that makes sense. And also, he mentioned that there's comparisons to the laws, or at least the court decisions, or the equivalent, of other countries, because this is a treaty, right? This is a Hague Convention. So lots of members of lots of different countries are members of this. So the decisions of other courts are probative and informative. We can consider them what we call in law persuasive authority. These are members of the same treaty, have analyzed perhaps similar issues, similar laws, so their decisions are persuasive. But of course, they're not binding on us. They're merely persuasive. So we can take note of them, and if they're persuasive, so be it. But we can ultimately interpret the law whatever we want, because it's, we're a member of the treaty, but we're having to apply it in our courts. So obviously, we have to have our own legal standards. So let's move on and see what we got going on here.
Annie, a problem with your position, I take it your view is this child taken to the United States at 8 weeks old has no habitual residence.
That is our position, Your Honor.
And if that's so, then there are many children who would not be covered by the convention. The whole idea of the convention was to stop unilateral decisions to move a child. And you would be taking out of the convention's coverage cases of very young children.
With respect, I disagree with the proposition that our approach would lead to a large number of children who do not have a country of habitual residence. First of all, we're talking in this case only about infants. Older children are evaluated under a different standard, and in all likelihood, based on their connections, their acclimatization to the country in which they reside, they would have a country of habitual residence. Even with respect to infants, we're dealing here with the unusual case where the breakdown of the parties' relationship was simultaneous with Monasky's pregnancy and the birth of the child. In any case where the breakdown of the relationship occurs later in time, in all likelihood, there will be an agreement between the parents as to where the child will live for at least the foreseeable future. But from the standpoint of the objectives of the Hague Convention, there's nothing wrong with recognizing that a subset of children will have no country of habitual residence.
The problem with the standard that says if the parents have to have an agreement, in many of these cases, the relationship between the parents is so acrimonious that the likelihood of a actual agreement is slim to none.
That would only be the case, Your Honor, if the acrimony was simultaneous with the pregnancy and birth. In other cases involving infants, the breakdown of the relationship may occur later in time, and if there was a meeting of the minds after the child's birth, that would be controlling. A single parent could not unilaterally disavow that agreement. But
you think this agreement is irrevocable? If there's I doubt that there are going to be very many cases where there's a written agreement. So you think that if at the beginning, at the time of the child's birth, there's a tacit agreement between the parents, that's irrevocable, and then if the relationship breaks down over a period of time, where you might otherwise infer that there is no longer any agreement, that would not count?
That's exactly our approach, Your Honor. The agreement, once it's in place, is irrevocable until the standard for older children comes into play, which would be an acclimatization-based standard. But for infants, once the parents have reached a meeting of the minds, a single parent cannot unilaterally disavow that agreement.
It's a tenable position. It's a position with severe consequences, but it's a tenable position. So, like the law, the way it's read, it's like you talk about acclimation. So, acclimation is presumably unchangeable by mere will, because the way the law is written. So he's saying, look, if they have an agreement, then that's an agreement and it's binding perpetually. it's an agreement with a lot of consequences. It solves his problem, but it's obviously an agreement. It's one that comes into some interesting place. So okay, let's carry on.
Counsel, we're talking about an international convention, and yet none of the other parties to the convention have adopted your position. The courts of Canada, the UK, the EU, Australia, and others have in fact rejected it. We have said one of the important guiding principles when interpreting the convention is what the other countries do. Why should we depart from that guideline here?
Well, that's a pretty outstanding question. If all those places have truly reached the opposite conclusion, we could reach a different result, but it is an international treaty, so why should we is a perfectly good question. Let's see what he has to say.
Your Honor, every circuit that has addressed this issue applies some version of the shared parental intent standard to infants. Some circuits apply the additional actual agreement requirement that we're urging this court to adopt, but every circuit applies some version of shared parental intent.
But you don't dispute the fact that no other country, no other signatory to the convention has adopted your position.
I don't dispute that, Your Honor.
That's a real problem. I mean, it's not exactly fatal, but it's a real problem. He's admitting that no other country to this treaty, and some of which have considered this question, have adopted his standard, and other places have considered it explicitly on point, apparently, and gone completely the other way. So it's not fatal, but it's a massive problem. One of the reasons for treaties are international harmony. So when you are trying to interpret treaties, one of the things you look to is what is everyone else doing, so that you can help to make sure they're conforming. And so it's the fact no one else has done this, it's a pretty big problem for your preferred test. So, all right, let's carry on.
But to the extent that this court is inclined to follow the approach of foreign jurisdictions, then the relevant test here is not the all relevant circumstances test advocated by Taglieri and the United States. It's the primary caregiver-focused standard that the relevant foreign jurisdictions actually apply in cases involving infants. And that's the EU Court of Justice in the Mercredi decision. It's the UK Supreme Court in the A versus A decision. It's the Australian High Court in the LK decision. All of those courts have recognized that in cases involving infants, it's the primary caregiver's connections to the country of removal that determine whether the infant has a country of habitual residence.
Get that out of Chief Justice Hale's opinion, and it seems to me that she made a huge point that this is family law. Families differ. There are vast differences. And don't treat these words habitual residence as if it's like a black letter tax code. They're more like a factual matter. And let the judge who's closest to it, even though he's not a family court judge, unfortunately, it's a federal system because it's a treaty. Let them hear all the evidence and decide it. And that's it. I mean, not 100% it, but that's it. And as soon as 9 people who know, I'm speaking for myself, know very little about this, start laying down black letter standards, all we're going to do is maybe help people in some cases and just cause chaos and hardship in others.
Well,
that's basically what I got out of her opinion. It seems to me that's the British courts. And that sounds pretty sensible to me.
Your Honor,
it's not often I say this, but I'm somewhat inclined to agree with Breyer here. This is a heavily fact-dependent issue. You need to look at the competing interests of them, and you need to look at the competing interests of the child. So you have at least 3 people's interests at stake here. And that's a heavy fact-intensive question. And so you'd send this to a trial court, because that's what trial courts do. They hear evidence and testimony and, try to make a decision that's in the best interest of the child. That's the way we normally think about this. And it's appeals courts and us are not in the best position. So let the trial court decide, and whatever they do should work, unless it's some, manifest error or something. So not so bad. Okay.
UK Supreme Court makes clear that while an all relevant circumstances test is generally appropriate, in the case of an infant, the infant's connections to her environment are formed through her primary caregiver.
Well, that may be in some cases. That may well be. And in other cases, maybe it isn't. I don't know every family in the world. And so, maybe we read it differently, but I've really read Justice Hale's opinion as just saying what I just said. So, judge, be careful. This is factual. It involves families. Don't adopt a standard. Just let them apply these words. Now, where is that? Where did I get it wrong?
Your Honor, the UK Supreme Court follows the approach of the European Union Court of Justice in the Mercredi decision. And Mercredi makes very clear that in cases involving infants, a primary caregiver-focused approach is the test that should be applied. But under any of the competing tests that we're discussing here today, the outcome is the same on these facts.
Can I ask you a question about your position that somewhat puzzles me? You think that in this case the dispositive question is whether there was an agreement between the parents. Am I right?
Yes, Your Honor.
And then you say that there should be review de novo. But that's if the question is whether there was an agreement between the parents, isn't that a pure question of fact? Why would it be reviewed de novo?
It would be reviewed de novo, Your Honor, because while historical facts would be reviewed for clear error, the application of the habitual residence standard, the actual agreement requirement, to those facts is a mixed question of law and fact.
Why is it a mixed question? Was there an agreement between the parents or was there not an agreement between the parents? It's a question of fact, pure fact.
Because there does not need to be a written agreement. There doesn't even need to be an express oral agreement. An agreement can be...
Was there a tacit agreement? It's a question of fact.
It is just as much a question of fact as a reasonable suspicion or probable cause determination, which this Court has held.
No, because those involve the application of a complicated legal standard.
Your Honor, the fact that we're here today would suggest that the habitual residence standard is less than straightforward. Lower courts are in need of guidance from appellate courts setting forth clear legal principles about how to make a habitual residence determination, just as lower courts need guidance about how to ascertain the existence of reasonable suspicion and probable cause. This Court emphasized the need for clear guidance in the Ornelius case, where it held that probable cause and reasonable suspicion are reviewed de novo. And it's not only courts that need guidance, it's parents who are confronted with these difficult decisions about whether to remove a child from a dangerous situation. They need to know if a child is removed, what is the likelihood that the child will be returned under the Hague Convention.
But it's over and over in the history of this convention is that they don't want any rigid tests. They don't want domicile, they don't want nationality. They want a totality of the circumstances. And the government points to the Seventh Circuit case, the Redmond case, and saying that no one factor should be considered controlling. You just take all the factors and the district judge should weigh those and come to a conclusion.
All right, Evil Coleslaw says no written agreement, no oral agreement. So the agreement comes from where exactly? Evil Coleslaw, I am with you on your confusion because apparently, according to this argument, there can be an agreement between the parties with no written agreement, no oral agreement, and no meeting of the minds. Yet, nevertheless, there can be an agreement between the parties somehow. And if there is that agreement between the parties, which there's no meeting of the minds, but somehow still exists, should be binding somehow. I'm not really buying this argument so far. Justice Ginsburg's question was pretty good. Justice Ginsburg says, well, why not just totality of the circumstances? That sounds basically right, for this kind of problem. It's like you don't want a rigid application. You don't want to look to nationality. You don't want to look to any single factor. You want to look to the totality of factors. That seems reasonable. I mean, it's complicated, but seems reasonable. It's a heavy fact. It's a very fact-intensive question at that point. but, not unknown to family law issues, so seems reasonable. Totality of the circumstances. Yeah, okay, fair enough. Let's press on.
Your Honor, the problem with that approach is that it will breed disuniform outcomes. It will prolong Hague Convention litigation. It will undermine the deterrent effect of the Hague Convention by undermining the clear rules that would otherwise apply in this setting. But to the extent that this Court is inclined to look at the approach of foreign courts, we would urge the Court to adopt a primary caregiver-focused standard. If the Court applies an all relevant circumstances test, however, it is essential that this Court not only adopt that standard, but then go on and apply that standard to the facts of this case. The Hague Convention sets a goal of resolving these cases within 6 weeks. This case has been going on for 4.5 years.
4.5 years is a long time, but apparently the law is somewhat ambiguous in this matter, and it's been going through the appeal process, and 4.5 years to get to the Supreme Court is not exactly unheard of. So, yeah, this one took a long time, but future ones might be cleaner. So, okay, carrying on.
Under Article 2 of the Hague Convention, signatory states have an obligation to use the most expeditious procedures available to resolve these cases.
On the standard of review, doesn't de novo review necessarily prolong the matter?
I don't think so, Your Honor. De novo review facilitates the development.
It's going to push everything into the Court of Appeals, then re-arguing everything that's already been decided by the district court without any deference, so people will take appeals much more readily.
Given the stakes in these cases, it's likely that the losing parent in the district court will appeal whatever the standard of review is. De novo appellate review promotes the development of clear legal principles that district courts can apply more readily, more expeditiously, and that appellate courts in turn can also apply in an expeditious manner. If this Court adopts an all relevant circumstances test, then it would be displacing the shared parental intent standard that every circuit applies, which is why it is of overriding importance that this Court—
Every circuit, not the Seventh Circuit.
That is not a case involving infants, Your Honor, the Redmond case. Every circuit that looks at the habitual residence of an infant applies a test that looks to shared parental.
Not to put too fine a point on it, but every circuit could be wrong. That's one of the reasons the Supreme Court exists. Like, every circuit that's considered this could be wrong. And if, like, other countries in the world, and again, this is international treaties, so looking to what other countries does is interesting. So, like, if every other country in the world looks to a totality of circumstances standard, then we should do that. If every circuit has said something contrary to that, well, it's real fortunate we're the U.S. Supreme Court, because we can, in one blow, wipe all that case law completely away. Because we're the Supreme Court. We can do that. It's magic. So, okay, let's press on.
Intent. Some circuits also look at actual agreement as part of that shared parental intent inquiry. The need for guidance from this Court is of surpassing importance because this Court would be adopting for the first time an all relevant circumstances test that no lower court currently applies in a case involving infants. In order to live up to the United States' obligation to use the most expeditious procedures available to resolve these cases, this Court should not only adopt a standard of review and a definition of habitual residence, but should go on and apply that standard to the facts of this case so that this 4.5-year-old litigation is brought to an end, so that district courts have guidance about how the habitual residence standard will be applied. On the facts of this case—
also, like, just by an aside, if the problem is that federal judges don't do family law because they don't, and so, like, they're ill-equipped in some sense to deal with family cases of this level of complexity, well, there's a real, like, practical solution to that problem. A court can appoint a special master. A special master is a person appointed by the court that has varying degrees of control of the case, depending on the judge's wish. And so the federal judge could find if an experienced, child judge that deals with these kind of custody issues. They could find someone experienced, from the local courthouses that they really like and say, Are you available? And they say yes, and say, congratulations, you are now junior judge of this case, because I'm going to appoint you special master. And special master can have varying levels of control. Typically, they do pretty much everything the judge would do and then submit a final report to the judge for a final decision. So typically, they consider all the evidence, they hear all the evidence. They basically run the trial, and they render a recommendation to the trial judge, who then can hear additional testimony and blah, 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 and so forth and so on. So there's a real practical solution to this problem. If the district court doesn't know what to do, and they feel like it requires a family court judge, well, they call up the federal courthouse. They call up the family courthouse down the street and be like, "Hey, anyone available? Congratulations, you're now an assistant judge." So that's one way to solve this problem.
Will it be brought to an end? The child is now in Italy, and no doubt the Italian courts would weigh in. So this determination of habitual residence is not going to settle where this child, the custody of this child.
That's correct, Your Honor. Hague Convention cases don't determine custody. They determine the venue in which child custody determinations will be made. The appropriate venue for this child custody determination is the United States. And in fact, there has been no child custody determination in Italy. The Italian courts refused to make that determination because Monasky's parental rights were terminated in an ex parte proceeding of which she had no notice and no opportunity to be heard. If AMT is returned to the United States, then there will be a full and fair child custody hearing.
But that will depend on the Italian authorities returning her. And given the position that they've taken up till now, that seems most unlikely.
Your Honor, we believe as a matter of comity that the Italian courts would return AMT and would adhere.
The court that has declared her a non-parent?
Your Honor,
do that?
As a matter of comity, we believe that the Italian courts would adhere to an order from this court directing the re-return of AMT.
I am dubious on that one. I'm dubious. I'm not putting it outside the realm of possibility, but in the same way, our court is the highest court of our country. Their courts are the highest of their country, and so the Supreme Court said, "Return the child." I would imagine that Italy's response would be, "Get bent." That would be my assumption. So I'm not feeling the comedy on this one.
There is precedent for foreign courts following re-return orders. In the Larby case, which is one of the cases that this court cited in its Chafin opinion as an example of a case where a district court issued a re-return order, the case went all the way up to the UK Supreme Court as to whether to adhere to that re-return order, and the UK Supreme Court ordered the child returned to the United States.
There hasn't been any case where we're talking about a time in the other country as long as this. This would be the longest period of time in which any re-return order has been entered, wouldn't it?
I don't know if it is the longest period of time, to the extent that Taglieri has concerns about the propriety of re-return. Those are issues that he could raise before an Italian court when we move to enforce the re-return order. But
he just contradicted himself. Because a minute ago he said, if you guys were to re-return, they'd do it as a matter of comedy. And now he's saying to the extent the father has concerns about it, he could raise it before an Italian court, which then, might be in a position to say no. So would they do it out of a matter of comedy, or would he have the right to raise concerns before an Italian court? You managed to contradict yourself in the space of like two paragraphs. Congratulations.
In the absence,
which would just delay the proceedings that have already been delayed far longer than the convention contemplated.
But, Your Honor, in the absence of a re-return order, the grave error committed by the lower courts will remain unremedied. As this court held in the Chafin case, a re-return order is typical appellate relief.
But I'm not interested, hypothetically, oddly enough, in the law. Suppose I were interested in how do we get to what's in the best interest of the child. Look at it from that point of view. What do we do? And I also think
Justice Breyer says he's not interested in the law, and Blackleaf dies a little bit inside.
particularly federal judges, don't know much about this. So in Italy, is there a family court? Or what do I do? I don't know. This is a genuinely open question. I don't know what to do if my object is to try to secure the best interest of the child. And you're familiar with this case? You tell me.
Your Honor, the best interest of the child would be furthered by returning AMT to the United States so that there can be a full and fair child custody hearing at which a state court judge steeped in family law issues can make a determination about who should have custody and what is, in fact, in AMT's best interest. But in the absence of a re-return order,
I'm sorry. I thought that there was a special order of the Italian court giving the mother some visitation rights, albeit limited. It's not clear to me that you're representing to me that there is no method or manner for her to go back to the Italian court and reopen or revisit the custody issue?
I'm not representing that there is no procedural.
So assuming, as I do, that there has to be something that can secure greater rights for her, why should it be here instead of there, assuming, and you don't want me to assume this, that the totality of the circumstances suggests that she has acclimated?
Your Honor,
I mean, after 2.5 years, even under the convention, you don't have to return a child who's been settled for greater than 1 year. So
that sounds kind of like fatal, right? Sounds like the convention says 1 year and 2.5 years. Sounds kind of fatal. So, like, I'm not feeling this guy's argument on many levels. It's tangled. It's messy. It's not in alliance with other courts. It's not. It's just, I don't buy this guy's argument. Seems wrong. So, yeah.
That's correct, Your Honor. That does not bear upon the availability of
the return, but I still am wondering why it is that it's the American court rather than the Italian court who should be dealing with the custody issue.
Well, first of all, because Italy was not AMT's country of habitual residence. So she never should have been returned to Italy in the first place. The only way to remedy that wrong...
Well, that's a really interesting question, because I'm not sure, unless we accept your premise that the mother's intent controls, but she was only here a couple of months when the father sought re-return of her. So it's hard to say she was acclimated in those couple of months either.
But, Your Honor, the question is whether AMT had the type of meaningful, settled, stable existence in Italy when she was removed at 8 weeks of age to establish a habitual residence there. And
how old is the child now?
She is 4.5 years old, Your Honor. AMT did not have that type of existence within her fleeting 8 weeks of living in Italy. The Hague Convention is designed to protect children who have a stable, settled existence. That is what is explained in paragraph 72 of the accompanying explanatory report. There will be some children, such as AMT, who don't form those types of settled connections to a country and whose return to the country of removal is actually detrimental to the interests.
Understand. Your position is that she had no habitual residence at that time.
That's correct, Your Honor.
Is that correct? Not that she had habitual residence. Oh, all right. So either parent at that time could snatch her, and possession would be 10/10 of the law, right?
The Hague Convention would not speak to that removal, Your Honor. That doesn't mean that the left-behind parent would be without remedies. The left-behind parent could seek relief, for example, under the Uniform Child Custody Jurisdiction and Enforcement Act. The left-behind parent would have the opportunity to participate in a child custody hearing in the country of removal.
The convention, which was meant to solve this problem of a unilateral removal, would not apply.
The Convention would not apply if a child had no country of habitual residence. But as the very foreign jurisdictions on which Taglieri and the United States rely, including the UK Supreme Court, the Australian High Court, and courts in New Zealand have recognized, not every child will have a country of habitual residence.
How long does the child have to – how old does a child have to be before you would say they have a habitual residence? 8 weeks, is, under your theory, is not enough, but 1 year, 2 years?
Well, at a certain point, around 18 to 24 months, the focus would shift to the child's own acclimation to his or her surroundings, because the child.
Where do you get that number from?
Based on the development of a child psychology, at a certain point, the lower courts shift their test from shared parental intent to acclimatization once the child has formed his or her own connections. Under the shared parental intent standard for infants, the inquiry looks at whether the intent of the parents is a proxy for the type of settled, stable, meaningful ties that an older child would be able to form. And there will be some children who do not have a country of habitual residence because they did not form the type of settled, stable ties that the Hague Convention is designed to protect. Returning a child to a country where it did not have meaningful connections is just as harmful to that child as permitting.
So, like, I buy the premise that there's, children to which they have no habitual tie. But then it's like, how do you decide between one country and the other in that circumstance? And the only thing that makes sense is a totality of the circumstances analysis. Like, an agreement would be part of that analysis, perhaps, but I don't think that would be dispositive, and he's arguing it's dispositive even if there's no agreement. So an agreement is dispositive even if there's no meeting of the minds, but there's still an agreement even if there's no meeting of the minds somehow. And, okay, that doesn't make sense. Totality of circumstances makes a lot more sense. Like, consider all the factors, put it before a trial judge, get some family court judges in there, why not? Yeah, that makes sense. And whatever country they happen to be in at the time makes sense, because what else are you going to do? Okay, let's press on.
The child's removal from a country of habitual residence.
Judge Boggs suggests that in the case of children who have lived in a single place for their entire lives, in the case of infant children, that is, who have lived in a single country their entire lives with both parents, that the usual rule should be that's their habitual resident, not irrebuttable, but that should be the usual rule, that's their habitual residence. And that's certainly a very administrable rule. It provides a lot of guidance, and it deters anybody, either parent, from taking the child anywhere else, which seems to be a value too. So why isn't the Judge Boggs rule the right one for infants?
The problem with that approach, Your Honor, is that it conflates a child's residence with her habitual residence. Mm-hmm. If the signatories to the Hague Convention had wanted to enact an agreement that was all-encompassing, that applied to all children, they would have prohibited the removal of a child from his country of residence without the approval of both parents. What they instead did was enact a more targeted provision that prevents the wrongful removal of a child from his country of habitual residence, because the signatories recognize that removing a child from a country of habitual residence where the child has meaningful ties, has a stable existence, would be harmful to the child. But they also recognize that returning a child to a country where it lacks those ties, it lacks those connections, would be just as harmful to the child's interests. That is the fundamental problem with the one-country rule advocated by the panel in the Sixth Circuit. But whatever the test is that this court adopts, the outcome is the same. The facts are overwhelming here, that as a result of the physical and sexual abuse to which Monasky was subject, she formed the intent during her pregnancy to return to the United States with her child as soon as possible. That's what the district court found at Pet App 94A, that Monasky intended to return to the United States with AMT as soon as possible, and that's what she did. The day that AMT's U.S. passport arrived, Monasky left and returned to the United States, fled from the dangerous situation in which she found herself. The signatories to the Hague Convention would never have intended to prevent a mother from removing her child from those dangerous circumstances.
Why? That's a question I have here. Of course there's child abuse or spousal abuse raised throughout this, which is a serious problem. So why is this case not involve Article 13, where you don't return a child if there is a grave risk that his or her return would expose the child to physical or psychological harm or otherwise place the child in an intolerable situation? That provision would seem designed for the problem of spousal abuse. Why isn't it here?
Justice, may I answer the question? Your Honor, we did urge the district court to apply the exception for grave risk of harm to AMT. Unfortunately, lower courts have construed that exception narrowly. And in this case, even though the district court credited Monasky's allegations about the extensive physical and sexual abuse to which she was subjected, the court concluded that that abuse directed to Monasky was not sufficient to create a grave risk of harm to AMT.
Thank you, counsel.
I mean, if it seems plausible, at least on its face, right? I mean, it's not per se that because you're abusive to the spouse that you'd necessarily be abusive to the child. The district court's in the best position to analyze, because we're all looking at the interest of the child, right? This is child focused. So he abused you, the partner. That's horrible in its own right. We're looking at the child, and so that might be informational, but not necessarily dispositive, and the trial court's the one to look at that along with all the other factors and try to reach some sort of cohesive calculation based on everything to determine what to do. And his standard that he wants to apply, the agreement without meeting of the minds, which both Evil Coleslaw and I are like, our brains are exploding, trying to comprehend what that even means. What is an agreement when there's no meeting of the minds? What does that even mean? It's like, you're talking nonsense. It's like nothing makes sense. So your standard doesn't make sense. So like, you know, his argument is not persuasive to me. Let's see what else we got. All right, who's next up on the list? So that was Amir Tarini for the petitioner. Next up, we got Sofan Joshi, Assistant to the Solicitor General, Department of Justice, as amici curiae, in support of neither party. So let's listen to what the Solicitor General has to teach us.
Mr. Joshi?
Mr. Chief Justice, and may it please the Court, habitual residence is a flexible, fact-intensive concept. That's precisely why the drafters and ratifiers of the Hague Convention picked it over the alternatives like domicile or nationality. It asks a very straightforward question. Where does the child usually live? Where's the child at home? Answering that question requires looking at the case-specific facts on the ground, unencumbered by rigid mechanical per se tests. That includes petitioner's rigid mechanical per se test about a subjective agreement or a meeting of the minds. That is not necessary to establishing a child's habitual residence. It's not even necessary to establishing a shared parental intent, which itself is not necessary to establishing habitual residence. And that test applies equally to infants and to older children. Nothing in the Convention's text or structure suggests that habitual residence carries a different definition depending on the age of the child. So that takes care of one question presented. On the other one, because determining habitual residence is primarily a factual inquiry and involves factual work, this Court's framework in U.S. Bank or Lakeridge applies, and there's no reason to deviate from that rule. In fact, that rule would also provide, we believe, the most consistent results, including consistency of outcome, as petitioner asks for. Because the best way to be consistent is to be right, and the best way to be right on a fact-intensive question is to trust the district judge.
That makes total sense, right? This is fact intensive. So de novo makes no sense. at all. So then it just becomes an issue of like, which differential standard do you want? Do you want clearer? Do you want abuse of discretion? Some other standard. But basically, the district court should win unless they totally fudge the case. So, that makes sense. Solicitor General makes sense to me. Let's carry on.
What puzzles me about your position, which does seem to reflect the decisions of foreign courts, and maybe something has just been lost in translation, but it's fine to say, take everything into account and be flexible. But that's not very helpful unless one knows the question to be answered after taking everything into account and being flexible. And so the critical point is what is meant by habitual residence. Now, you said it's where the child usually lives. If that's the test that Judge Boggs had, I understand it. But if it's something more than that, then I really don't know what habitual residence means.
So we think where a child usually lives is the test, and it's sort of hard to explain it more than that. In most cases, it's going to be quite easy to tell where the child usually lives, including for infants. I mean, I would wager if you walked on the streets of D.C. and found parents with infants and said, where does your infant child usually live? They'd say, with us at home. And it's oftentimes when these cases are in dispute, when habitual residence is in dispute, and it's a very small fraction even of Hague Convention cases, in those situations, it's going to be very hard to come up with an ex-ante rule or test that's going to be useful in that circumstance.
Well, what if the parents live from the time of the child's birth until the time when the issue comes up in a particular country, but it was never their intention to stay there permanently? Would that country be where the child usually lives?
That's a very difficult question, and I can imagine many factors that might push you one way or the other. For example, if that's where they had been living for quite some time but just had some future plans to move, that might well be where the child was usually living on the date of immediately before the wrongful retention or removal, as Article 3 calls for. On the other hand, if you're telling me that, in fact, they have a permanent residence in another country and they were, in the country of birth just on vacation and she went into early labor and the child was born there, but all their connections are back in the other country, it might be a much more difficult question. The point is, where habitual residence is disputed in those small fraction of cases, there's very little ex-ante guidance that's going to be useful, except to say the question is, where does the child usually live? Or if it helps to think of it this way, where is the child at home?
Well, that's kind of a meaningless concept, where the child usually lives, if you're talking about somebody who's 8 weeks old.
That's fair.
Again,
it's not as if they laid down roots. 8-week-old infants don't have habits. Well, other than one or two, but it doesn't seem to me that that's the notion that the convention drafters were looking at.
It isn't, and I think it's important to realize that although the word is habitual, the term habitual residence and the use of the word habitual originated in the Hague Convention in French. And the English copy here is official, but nevertheless the term habitual residence began as, I'm not even going to attempt to pronounce it in French, but habitual in that context translated means usual or customary. It doesn't necessarily mean as a habit. And I think it's important that in the ordinary case, even an infant, as I said, I think ask the parents of any newborn, and I think if you ask, where do you usually live, they would have an answer, just like...
What does that mean? Judge Boggs is right, that the place where an infant usually lives is the place where the infant has lived since birth with both parents.
Judge Boggs may well be right, and he did add the qualification for absent unusual circumstances.
Absent unusual circumstances, right.
And I think that's perfectly fine. I think the problem, though, is if there's any sort of guidance like that coming from this court, lower courts will tend to rigidly follow it instead of answering the ultimate question, which you asked about earlier, which is, where does the child usually live? As a practical matter, and and in theory, the judge can consider facts that are relevant to that question, and of course that itself is a constraint.
There's a problem with your solution. On the two questions presented, I take it you agree with respondent. But you said the bottom line should be a remand, not a determination. And this child is now 4.5 years old. To remand, to do what? What factor didn't the district court take into account that the district court should have taken into account? You say totality of the circumstances, not just shared intent as a single factor. But it seemed to me that the district court did have everything before it. What if we remanded, what should the district court do that it hasn't already done?
So, Justice Ginsburg, we don't take a position on the outcome of this case. The Court's usual practice when announcing a new standard is to remand. The only thing I'll say is that both the Court of Appeals and the district court appear to view the facts through the lens of a notion that shared parental intent was the only thing that mattered, and probably the parties briefed the case that way in the Court of Appeals, all to shared parental intent. To the extent there are other facts that might have been germane to determining where the child usually lives that the parties didn't bring forward,
What would
we
they
just don't.
be?
I don't know, and it's hard to predict. I would, as an example, I'll give you a very recent case that's posted on the Hague Convention site that tracks cases under the Convention. It's called X against Y. Those are pseudonyms, obviously, from the Court of Appeals of The Hague. Mom alleged that the apartment in the Netherlands was where they usually lived. Apartment in Spain was a vacation home. Dad alleged exactly the opposite. Court had to decide who was right, looked at a lot of facts on the ground, but the most compelling one that the court decided would tip the issue was that the mom had deregistered herself from the municipal persons database and put Spain as her forwarding address, and deregistered the company she ran from the Dutch Chamber of Commerce. It's impossible to predict that that was going to be the fact ex ante, but when you're looking at where the family in that case or the child usually lives, it's the parties who are going to come forward with evidence, and the judge is going to decide whether it's relevant, and if it's relevant, assign weights to it.
So would you agree then with Lady Hale's observation in terms of a young child, infant, and parent intent, shared parent intent? She says that these common sense observations are best seen as helpful generalizations of fact, which will usually, but not invariably, be true, not as propositions of law. So Hale, Boggs may be right, except that he's calling it a proposition of law.
I would agree with that, and I would just, again, I would caution this court from laying down principles like that, because when this court says it, lower courts usually take it as proposition of law.
Well, then if that's so, then is it the less risky path to send it back? If we say it and don't send it back, more likely to be taken as laying down propositions of law?
That may well be true.
What do you think?
So we don't take a position on it other than to say, ideally this court's opinion will say that habitual residence is...
No, you don't have to take a position, but I find it rather difficult. So can you help me?
Again, as I said, it's where the child usually lives, and with the facts we know...
Where did you get that standard? I look at the European Court, and it had a different standard. It says some degree of integration by the child in a social and family environment. That's the definition the Bates Court, Lady Hale, adopted. I think once we say where a child ordinarily lives, we fall into the trap that you had, which is I think courts will be focusing on ordinary out of context. Are you disavowing what the other courts are doing?
No, we're not, if I may, Mr. Chief Justice. We think they are looking at the right question, which is where the child ordinarily lives. In difficult cases,
no, that's a translation. They didn't use those words.
We think the words they use are certainly relevant to that ultimate determination, and in any event, that is what the text of the Convention says, and we think that's what the Court should apply here.
Thank you, counsel.
All right, well, on the whole, seems fairly reasonable. Basically saying that, there's marginal cases like the woman on vacation who gives birth in a foreign country, so asking habitual there wouldn't make sense, but absent the unusual cases, you're looking for where the child what they would ordinarily call home, which I suppose in the case of the mother on vacation, what they'd ordinarily call home is their home country, notwithstanding the fact they're born overseas. They're a brand new baby, but still what they would ordinarily call home would be their home place. They just happen to not be there at the moment. So maybe even in that example, it's workable. But absent, some unusual circumstances, absent, some other things, we're looking for this ordinary place of living as the standard. Seems reasonable. I like his argument a lot better than the first guy. All right. So now we're going to hear for the respondent. Let's hear what the respondent has to teach us.
Mr. Pincus?
Thank you, Mr. Chief Justice, and may it please the Court. Just to pick up on Justice Sotomayor's question, I think the European and UK courts have talked about the family and social environment in which the child's life has developed. I think that, to me, is not that different from where the child usually lives. It may avoid the problem of duration. I think a lot of the problems in these cases sometimes result from the fact that habitual residence into a U.S. Ear may connote some degree of permanence, but the foreign courts have made clear that that actually isn't the case. It doesn't require permanence. It's just what's usual during the period before the allegedly unlawful return. We agree with the SG regarding the test, and I just wanted to start by saying a few words about Petitioner's actual agreement test. As Justice Ginsburg pointed out, it would largely eliminate the Convention's protection for very young children, because they would have no habitual residence. And because one of the spouses, in the cases where there is marital discord during the pregnancy and the birth, could simply say, I withhold agreement on where the child should live, and that would mean there was no habitual residence as long as there was no agreement. That's obviously a significant gap. Petitioner cites some cases saying that a child may not have a habitual residence, but I think it's important to point out that those statements were made in a very different context, which is actually the one presented in the very large majority of decided Convention cases. And that's the situation where the child and the parents live together in country A. Then the child moves to country B with one or both parents. It could be a temporary stay with grandparents, could be for a job. And then the parent who is with the child in country B says, I'm not sending the child back. And so the question is, what is the child's habitual residence, country A or B? And courts have said in that circumstance it's possible to lose the habitual residence in A before gaining it in B. Whether that's true or not, that's obviously a very different situation from the one presented here, where the parents are in one country and the child is born there and stays there until the challenge removal. And we agree with Judge Boggs, as a factual matter, not as a legal principle, that those facts are very likely to lead to the conclusion that the child's habitual residence is that country, absent unusual circumstances. There can be different facts. The child's born on vacation. The child is born at a place of birth selected for medical benefits that were provided. But that also makes sense. The reason for identifying the child's habitual residence is to determine which country should make the custody determination. And if the parents of child and the child have lived in only one place, it's logical for that country to make the determination, again, absent unusual circumstances.
Which, as you say, is what Judge Boggs said. And so I'm curious as to why you're not just accepting that as a formulation of the legal standard. Judge Boggs was careful to say, absent unusual circumstances. And I suppose I would say that the benefit of doing that is, if you take this Solicitor General's test, this is on page 26 and 27, I'm not going to read it because it would take too long to do all the factors that they think ought to go into this inquiry. And I guess I'm a little bit afraid. I don't mind totality of the circumstances tests when they make sense, but I guess I'm a little bit afraid that by the time you get through all those factors, everybody's going to have forgotten what the ultimate question is. And if the ultimate question is just, where does the child usually live, then why not just sort of say that when it comes to an infant or a very small child, the child usually lives where the child has lived with both parents all her life.
Okay, so that's a very reasonable line of thought from Justice Kagan. So points for Justice Kagan. She adequately shows some weaknesses in the Let's Explore Everything test. It's by its nature very complicated, right? All the factors, consider everything. It's a very complicated test. It's considering a lot of things. Everything goes into a mix. It's requiring a lot of testimony, a lot of evidence, a lot of stuff. It's workable. It's something that can be done, but it's like, what is the question we're trying to solve? What is the ultimate question we're trying to reach? So, If it's like what's in the best interest of the child, totality of the circumstances makes more sense. If the question is what's the habitual domicile of the child, then, absent unusual circumstances, where the child has lived all their life, whether that be a day or a week or a month, is the problem fundamentally is someone somewhere has to make the decision, right? Two parents are unhappy with each other, and one child wants to take the kid somewhere, and one parent wants to take the kid somewhere else, and some court has to have jurisdiction. So where? That the parents one parent is of country A, one parent is of country B, the kids in countries in the kids in country C, with people of nationality D. It's like, who's making this decision, right? Which court is making the decision? And totality of circumstances doesn't tell you that. It doesn't tell you what court should make the decision in the first place. So she's saying, look, let's make this simpler. Let's make it simpler. The question is just, where's the child normally domiciled? If they're 1 day old and in the nick of a hospital somewhere, then so be it. That's where they're normally domiciled, in the nick of the hospital. That's the country of origin. It is an answer to the question of which court should decide. Got to give it to someone. This is the question we're trying to solve. So absent some sort of abnormal circumstance, this is something that's very clean to apply. I like Justice Kagan's analysis very much. Let's carry on.
Well, I don't want to resist a rule that would be beneficial to my client, but I guess I will say that the courts, especially in the UK, have had a lot of experience with subsidiary legal.
And yes, it had to be someone who brought up the children of Antarctica. I suppose that would be fall into the unusual circumstances. And I guess it would matter, like, where in Antarctica are you? Are you at McMurdo Station? Then I guess you're in the United States. Moving on.
Principles like that being developed, and I think the result, and I think Chief Justice Hale mentions this as one decision, is that they do get too much credence in how lower courts approach the case. And so I think the danger of adopting subsidiary legal rules is that they will end up being applied, as the Solicitor General said, in a broader context than they should be.
Wouldn't all the work be done on absent unusual circumstances, though? And so you would still have the out, as Justice Kagan points out, for people to argue that it's...
I think so, and I'm not sure that, Justice Kavanaugh, that there's much difference between saying that as a legal principle or framing it the way Justice Breyer did, which is when the facts are that the child has lived in one country with her parents for her whole life, absent some unusual facts, that is going to lead to this decision.
Well, what this take everything into account and be flexible standard seems to mean in practice, and tell me if this is wrong, is there are a lot of different considerations, and particular considerations may be more important in one case than in another case. So we're just going to dump this in the hands of a particular judge to make a decision that that particular judge thinks is fair in accordance with that particular.
Next person who mentions penguins gets banned.
Judges' value judgments, and we're going to make it very hard to get that reversed. That's what this all seems to boil down to, with a lot of highfalutin language by the foreign courts. Am I wrong on that?
I'm not sure that that's right, Justice Alito. I think there is an ultimate inquiry. Where does the child usually live, or in the European version, the family and social environment in which the child's life has developed? I think that gives you a North Star. I think the problem is there are a lot of different facts in these cases. It's one reason why in family law, best interest of the child is a very broad standard, because there are a lot of different facts.
But
so I think you can lay out, as this colloquy indicates, you can say, for example, when you have a child who has lived only in one place, there is a pretty clear factual result that's going to obtain absent something odd. The difficult cases really are these multiple country cases. Those are the cases where there are a myriad of fact patterns. Why did the child move? What were the parents' views when the child moved? Did the child get acclimated to the new country?
Well,
those are very complicated.
In the case of an infant, why does it matter that the infant has lived all of his or her life in a particular country. That it wouldn't matter to that infant what country the infant was living in or whether the infant was living on the moon. The infant's world is the home with the parents or a parent. So why does it matter?
Well, it matters that the infant has lived in the same country with the parents. That's the critical, I think, additional fact. And I think...
But what is the interest that is served by that?
There are two interests that are served. One is, the theory of the convention is finding habitual residence is important for two reasons. One is to identify the place where the custody determination should be made, as opposed to leaving it to the unilateral decisions of one parent or another. The second is to deter these abductions, which are not only harmful in that they allow the gaming of jurisdictional rules, but they're harmful because they take the child away from both parents. One parent is unilaterally taking the child away from the other.
In this case, it's a troublesome case because she alleged that she was abused. So you're putting that mother in the position of, if she wants to escape domestic violence, she has to leave her child behind.
Well, she doesn't have to. She can escape domestic violence by separating from her husband and staying in the country. Before she left, she spent 2 weeks under the protection in safe houses under the protection of the mechanisms that Italy has for that purpose. So I don't think that the test requires that she stay with the husband. I think one of the unusual facts could be in a situation where it was clear that the abused parent wanted to get away, was determined to get away, and the evidence is the husband thwarted her at every turn. That's not what the district court found here, however, because the district court found, and just to quote two findings, on Petition App 98A, she continued after the birth of her child to live in Italy and had no definitive plans to bring her to the United States until the last altercation, which precipitated her departure. And at 94A, most of the steps that Monasky took in March 2015 seemed to reflect a settled purpose and intent to remain in Italy, at least for an undetermined period of time. So the district court looked at all this and said that wasn't the case here, and I think those are actually factual findings. Those aren't even mixed questions.
What do we do about it? I mean, I think in their brief they said she doesn't speak Italian and doesn't have a job. And what do you do about, and this standard that I read, he didn't mention this, but it says you can't place the child in an intolerable situation. Well, you think where the mother is being beaten up, that would be an intolerable situation. And what do you do if the mother is in a country where there are difficulties with abused women finding adequate care, and she's got to get out of there? All right. Well, what do we do about that?
As I say, I think that could be a relevant fact that might lead the general rule that we're talking about.
Do we put it in here, or do you say in dicta or something that it was raised an intolerable situation includes that, or do we say nothing at all?
Well, there are two options for addressing that, right? One is to say that if the district court were to find that the mother was trying to get away and she had at the quickest possible moment, but she was thwarted because the father was preventing it through abuse or otherwise, then that might well mean that there is no habitual residence. That is not, as the findings that I read, that's not the case here. You could also look to the Article 13 exception and talk about the possibility that those facts may be relevant. As my colleague noted, that was...
Isn't Article 13 about abuse of the child?
It is about abuse of the child, and so that requires a broader finding. So it may be that the first approach is a better one.
Let me ask you a question about the difference between you and the government. You, I thought, urged that shared parental intent is relevant but not dispositive, one factor among others to be weighed. But if that is the case, doesn't that suggest the government's position a remand, because at least the majority of the Sixth Circuit seems to focus on this shared parental intent?
Well, let me answer that in two ways, if I may, Justice Ginsburg. First of all, I think it's important to unpack the phrase shared parental intent. I think the way the lower courts, as we discuss in our brief, the way the lower courts in the United States have applied that is what's the intent of each parent? That can be proven by words, deeds, objectively. What is the parent's intent with respect to the location of the child? There's perhaps one case in which a federal court of appeals indicated that a meeting of the minds might be necessary, and even that court relied on an alternative ground. So I think the question is the intent of the parents with respect to where the child lives relevant? I think yes. It can be proved they don't have to have jointly agreed. They can each have the same intent. In terms of this case, I think if we prevail on the legal issues, then that issue is determined because there's no clear error in the district court's determination. So the question would be, are there other facts that would be cognizable under the habitual residence standard that the lower courts didn't address? And our submission is those other facts are all facts that weigh in favor of Italy because they're principally the fact that the child has been located in Italy for her whole life before she was removed. And that's not something that was relevant necessarily to intent, but that's clearly a highly important fact that she was there with both parents. And so we don't see any other facts that can be adduced in this record. 4-day trial was quite comprehensive. We don't see any other facts that could be relevant to that would require or even permit a different determination on the habitual residency determination, which is why we think a remand isn't necessary.
When you, and to the extent you know it, the SG, talk about totality of the circumstances, for older children, does that mean rejecting the view of most of the circuit courts that the key thing is acclimatization?
No, I think acclimatization as children get older it can be highly relevant, and the courts that have adopted this test, the foreign courts, have said that. I think the problem—
Well, but I think most courts have done more than just say that's highly relevant. Most courts have said that's the question that we're trying to answer. And that provides a kind of anchoring mechanism for courts, right? Okay, now I understand what the question is. It's a kind of embeddedness in a particular country's life. So, but if it's just like one thing that gets thrown in along with everything else, that seems sort of different to me.
I think the problem is there's no bright line between when you might think the young child standard applies and when you might think acclimatization becomes relevant. There probably are crossing lines. At one point, it's really about the young child and is he or she with her parents. And then at some point later, when the kids are 15 years old, it may be much more about them than about parental intent. I think most courts have been reluctant to say the parent's intent becomes irrelevant. I think the courts generally say acclimatization becomes much more relevant. So I wish I could help you with saying that there's a dividing line there.
Isn't that what the European court said with respect to infants? It didn't say that you put parental intent or agreement as being the most important. It used the word just an important factor, I think, with their language.
That's exactly right, Your Honor.
So how do I discern that the mother's intent was to stay in Italy or that the child had acclimated to Italy or integrated into Italy when the child was during those 8 weeks, she was moved from one spot to another? She didn't live consistently with the father.
Well,
they
she
were
moved
separate
between two places.
Between two places, but the father wasn't in the first place. Then the mother went for a couple of weeks with the father and then brought her back into the shelter. The mother, I think, had some fairly potent evidence that she was making plans to leave Italy. Everything about the entire situation surrounding this child was simply up in the air.
Well, I think
why couldn't a court reasonably conclude that no settled place, ordinary place had yet been formed for this child? That's a possibility we haven't talked about, but I have to presume that if we tell a court that it's the totality of the circumstances, that it is in fact one of the options it has.
I think it is. In this case, I think the portions of the district court's opinion that I read on page 94A and 98A preclude that in this case because the district court rejected that as the mother's intent. I think for the reasons that we've been talking about, and I'd also say the movement from place to place is something that lower courts have rejected if it's within one country, because the idea here is to find the country of habitual residence. And if those movements, the Second Circuit said, speaking through Judge Cabranes, if those movements are within the country, they don't really count when they're within two places. I wanted to mention Justice Breyer raised a question about Italy and what the proceedings might be there. There is a proceeding in Italy, a custody proceeding, that a petitioner actually this past October has filed a custody petition. She filed some prior petitions. They were rejected on jurisdictional grounds. As I understand it, this petition is in the right Italian court and raises the custody question.
But what about this ex parte declaration depriving her of her parental rights? That's still standing.
I think that's one of the issues that will be adjudicated in this Italian proceeding. And as Justice Sotomayor pointed out, the current status is that the legal custody of the child is with the Italian authorities. The father has generally physical custody. The mother has visitation rights. There are periodic reports being filed by the Italian Social Services Authority about what's going on. So the Italian authorities are pretty seized of this matter. So just to return to the question of the remand, I think our view is, for the reasons I was discussing, that the district court's findings really deal with the intent issue, his factual findings, putting aside his ultimate determination on habitual residence. All of the other facts that could possibly be relevant under the Judge Boggs standard framed as a factual presumption, we think weigh in favor of Italy as the place of habitual residence. And we agree that it would be great to cut off these proceedings. Tomorrow will be the 3-year anniversary of AMT being returned to Italy. And it would certainly be good for this uncertainty to be lifted so that the Italian authorities could proceed with the custody determination without this issue being raised. And I do think, as several members of the court said, that there would be significant problems with the issuance of a re-return order, both in terms of a U.S. court's ability to issue such an order given the equitable considerations and also the extent to which such an order would be accepted by the Italian authorities. Unless the court has any further questions. Thank you.
Thank you, counsel.
So, yeah, this pretty good stuff dealing with, the standard that we're trying to apply and also its applicability to the current case. Because basically one of the things they're talking about here is they seem to be contemplating the possibility of declaring a new standard but not remanding the case. So presumably they would say, we're affirming this case, and oh, by the way, going forward, here's the new standard for future cases. So even though you appealed, we're not going to apply the standard to your case. That'd be a little unusual. It happens sometimes in criminal law, where cases don't have retroactive effect for various reasons, but this isn't a criminal case, but it does have some complications with it. So, it'd be a little unusual to do that. But, I think they're right here that the idea of remanding this is problematic because the child isn't here. So district, and if you remand it, what's the court supposed to do? And you announce a new standard. It's and if you issue a return order and the Italian authorities thwart you, which seems pretty likely, then you've created an international situation here, on a very messy situation. So, yeah, either uphold the decision of the court below, say they came to the right standard, or I don't even know what that would be. I guess technically you'd be reversing, but not remanding. That would be a new thing. So technically you'd be well, no, I guess I guess you do it as an affirmation. You'd say, yeah, you affirm the judgment and say, but your legal standard was wrong. And by the way, here's the new legal standard for cases going forward. And try to ignore the fact that you're not applying that standard in this case. Not the greatest solution of all time, because it does leave this one person out in the wind, but at least it clarifies the record and hopefully prevents situations like this going forward. So this person is out of luck in the name of the greater good solution has some appeal to it, but it would be pretty interesting. Railway Hacker said, I like some fact finding on the age at which an infant changing country language has negative impact. That's a good idea, but the problem with that idea as it applies to the law here is that the convention, the Hague Convention that this is being decided under, doesn't differentiate on the basis of age. It doesn't differentiate on age. It doesn't bring up age as a factor. Or to the extent it does, it would be one factor among many, right? It doesn't like say, here's a rule for infants and here's... So like you're trying to find a rule that's consistent for all age groups. So like 1 day old or 10 years old, you're coming to some sort of legal analysis. If that's habitual place of residence, then so be it. If it is some sort of all amorphous standard, then so be it. But yeah, what age do they become acclimated is not quite the right standard. So let's listen to the remainder of this argument.
2 minutes, Mr. Tehrani.
Thank you. 3 points, Your Honor. With respect to the standard applied by foreign courts to cases involving infants, I would point the court to paragraph 55 in the European Union Court of Justice's decision in the Mercredi case. The court there stated that an infant necessarily shares the social and family environment of the circle of people on whom he or she is dependent. Consequently, where the infant is in fact looked after by her mother, it is necessary to assess the mother's integration in her family and social environment. That is the standard that Lady Hale adopted in the A versus A case at paragraph 54 sub 6. Applying that standard in this case leads to one clear, inexorable conclusion, that Monasky was not integrated into a family and social environment in Italy, and therefore AMT did not have a habitual residence in Italy. This court need look no further than the party stipulation at JA 28 and JA 29 that as early as August of 2014, Monasky was already laying the groundwork for her return to the United States by looking for U.S. healthcare and childcare options, U.S. employment, and U.S. divorce lawyers. This court need look no further than JA 200 and JA 217, which are emails between the parties sent in the critical days preceding and following AMT's birth, where Monasky reiterated her intent to return to the United States and to divorce Taglieri. And this court need look no further than Pet App 94A, where the district court found that Monasky intended to return to the United States with AMT as soon as possible. That's precisely what she did. The day AMT's U.S. passport arrived, when AMT was 8 weeks old, Monasky fled the dangerous situation in which she found herself and returned to the United States. This court can and should make that determination, and it should order AMT's return to the United States for a full and fair child custody hearing, which is the only venue in which that hearing can take place. Thank you.
Thank you, counsel. The case is submitted.
Okay, well, that's a lot of... That's really interesting stuff. I mean, for me, that's one of the more interesting cases I think we actually wound up covering, just because there's like, the uncertainty of how to measure this and who should be measuring it, what standards should apply, and the fact that it's an international treaty makes a whole new level of complications to it. So that was very, very legally complicated. It's also legally complicated for me in particular, because family law is, by very deliberate decision of mine, and not a area where I know very much. I kind of noped out of family law pretty rapidly in law school. I was like, I just don't want a piece of this world of pain, and leave it for someone else. So like family law is probably the area of law I know the least about as a result. And so, I like to admit my areas where I'm less able to answer questions, because I, want to be as honest with you as possible. And family law is definitely one of them. And now we're in family law and international law and uncertain standards and a treaty. And like, I am in over my head on this one. But I think the petitioner's argument is the one who's appealing. I didn't like what he said. I found his argument not to be very persuasive at all. So I think reverse seems unlikely to my mind. If you have to guessing reverse is usually good, because I think the court ends up reversing like 65% of the time. But I found petitioner's argument very weak. I found the standard very weak. I found the logic of it very weak. And the fact that it's apparently not in alliance with any of the Court of Appeals and not in alliance with any of the foreign courts. So all the foreign courts are wrong. All the courts of appeal are wrong. It's like, you have to have a pretty good explanation if you want the court to buy that. And I didn't hear anything along those lines that seemed satisfying to me. So, yeah, so very, very interesting. Higgins, in answer to your questions, someone recommended it to me. And in looking at the ones someone asked if I'd cover it. And so I do take suggestions. Someone asked me if I'd cover this case, and I said, sure, why not? I looked at the ones that were interesting. There were several that were very interesting today, but this seemed like a good one. I'm really happy we did, because I think we learned a lot on this. It really pushed my mind trying to think through the complications of this and think through the legal issue. But I think the district court's in the best position to analyze the questions. The questions are principally factual. And I'm going to say, with no particular confidence in this prediction, but I'm going to say decision of the court is to affirm. I think they're going to affirm the judgment, and they're going to clarify the legal standard that should be applied, up to and including announcing a completely different legal standard than was below. So, and I don't think they're going to remand it, because I think it just would be too ugly. So I think any change of the law that's going to be done here will not apply to this case. I think it's only going to be forward-looking, which again is unusual, but given the whole set of circumstances, it seems like it's the most reasonable thing to do. It seems like the most reasonable thing to do. So my prediction is to affirm. My prediction is the Supreme Court is going to either confirm or modify or flat out reverse the legal standard, but either way, it's not going to apply to this case. So they're going to say the decision below is affirmed, the decision below is final, and by the way, here's the new decision here's a new test the courts should apply to this, whatever that's going to be, and go from there. And given everything that, what is the legal test the Supreme Court's going to actually say? Given the goals of the convention, given that's supposed to be done in a 6-week time frame, apparently according to the convention, then you're looking for a simpler test. Like all circumstances tests could get very, very complicated. So like a simpler test seems rational. So then you're left with the child's usual place of residence, absent some sort of unusual circumstances. So up to and including the child's place of usual residence being the NICU that the child has been in because they're a preemie, that is the country of the place of permanent residence, absent at ordinary standards. And so you can't remove the child from that country unless in violation of the laws of that country. Now, if you're in compliance with the laws of that country, then you could remove it to somewhere else and it becomes someone else's problem, presumably. So it's not like that necessarily means that the child's stuck there, because, that wouldn't normally be for like a tourist visa. Normally tourist visas expire and you go back home. So that seems like the most reasonable standard. Absent some sort of special circumstance, the place that applies is the child's usual place of residence. And it doesn't matter how old the child is, whether they're 1 day old or 10 years old, because the treaty doesn't differentiate. So the court shouldn't differentiate. It just becomes a much easier test, I suppose, if they're 1 day old and their place of residence has been than an ICU this entire time as opposed to a more complicated analysis. But either way, the test becomes a little simpler. And so therefore, the child's place of usual residence was Italy. And the district court could have taken note of the article, which allows them to disregard that because it's in the treaty, allows them to disregard that in view of threat to the child or psychological welfare or physical threat to the child. So the court could have taken note of that and not applied it for that reason because it's in the treaty. The court chose not to, and the court, being the trial court, the factual court, is in the best position to understand this. So absent, take your pick between abuse of discretion and clear error, the trial court's decision should be upheld, which allows for faster judgments too, because it becomes very easy for the Court of Appeals because it's just an instant affirm, 99% of the time. So I think that's probably the result based on everything. And I really had to really think about it. And that's one of the reasons I like that fact that we did this case, because I really had to think about it, because it's an area of law that I know very little about. It's an area of law that's very complicated. I really had to think about it as we were listening. And so it was very intellectually satisfying. As for the vote, I'm going to say the vote's 9-0 to affirm. I don't necessarily know that means there will be one solid opinion, though. I think it's quite possible you'll see a 9-0 to affirm, but differences in the rationales. So I don't even know necessarily you get to a majority opinion. So 9-0 for the result, but what the legal test is will be fractionated probably. But it doesn't really matter in terms of counting, in terms of the prediction. So my prediction is 9-0 to affirm. Whether or not we come out with one opinion or two opinions or three opinions as to the legal standard is a much more interesting question. I think the sub-majority will probably be going for what I just said, and there might be a sub-minority for more of a totality of circumstances case. But I think you probably get 5 votes for the place of regular domicile absent unusual circumstances. That seems to be where the court is going. So my prediction, for what it's worth, is 9-0 to affirm. So let's see how that works out, I guess. But I really enjoyed this. It was super interesting. Super interesting. And Higgins, you initially said reversal. Our 70% reversal is prediction. Yeah, because I said 65. It might have been 70. Yeah, something like that. But I really had to think about it. Really had to think it through. And I don't have super confidence in it because it's an area of law I don't know as well. That's this area, that and tax law, right? Because tax law is endlessly complicated, and childcare and family law is something I want no piece of. So those are the 2 areas of law I know the least about. So I really had to think it through. I'm really happy we did this case because it really made me think very hard. And I thought the bench was very sharp. I thought they had really good questions today. Some really good points, some really good rejoinders, really good challenges for all the advocates. But the guy who spoke first, the petitioner, I thought was the weakest. I thought his legal standard was complicated and didn't really make sense on its own merits. And then he said, oh yeah, by the way, now the courts of appeal agree with me. And oh, by the way, the courts of the EU, UK, Australia, blah, 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 also disagree with me. So I don't see petitioner winning this one. So 9-0 affirm is my best prediction. So I hope you enjoyed the stream because I really did. It really made me think. Really challenging case. And one of the reasons I love doing doing SCOTUS React is because it keeps me informed on law and makes me really think through stuff, keeps me sharp. It's really good for me. So if you liked this stream, I would appreciate it if you gave this stream a like. It really does make a difference. And as always, I'd appreciate it if you've not already done so on liking me on Facebook. And you know where to find me on Discord. Feel free to get me there. And if you want to ever recommend a story to me, You can message me on Facebook through Facebook Messenger. That's a good way to find me. Or you can tag me on Discord. It's a good way to find me. Or you could even leave a comment in YouTube comments. I'll probably see it. But probably Messenger or Discord is probably a better bet. Facebook is probably your best bet to message me. And that's all for now. It was a very informative stream. I had a really good time. I hope you did too. Until later, my friends, I hope you're well. Until later, cheers and goodbye.